When people ask, why do firms like Fearless Fund exist? Well, they exist because we have massive disparities. You got a whole demographic of women who are founding businesses at a faster and higher rate than any other demographic, yet they're not receiving the same access to capital.
This is Ayanna Parsons, a venture capitalist and co-founder of the Fearless Fund. Founded in 2019, the Fearless Fund is a venture capital firm that specifically invests in entrepreneurs who are women of color. For Ayanna, Fearless Fund's mission is aligned with her broader goals of diversity, equity, and inclusion.
I think when you have a lived experience as a Black person in America, there's this driving force to want to level the playing field for those who've been marginalized or underrepresented, because that's been me, my entire life. So I think that's really what drives my appreciation for the value and impact of diversity, equity, and inclusion.
Diversity, equity, and inclusion, often referred to as DEI, are a set of principles purportedly intended to promote equality in workplaces and educational environments. But while DEI may seem like an incontrovertible good, many DEI initiatives have come under intense scrutiny over recent years, culminating in President Trump's executive order to terminate all federal DEI programs.
Diversity, equity, and inclusion, those seem like concepts that sound good. And there are certainly some disparities in our society. And many times those need to and should be addressed. But it doesn't mean they need to be addressed on racial terms. And in fact, they shouldn't be addressed on racial terms.
Thomas McCarthy is one of the founding partners at Consovoy McCarthy, a law firm that helped bring a civil rights case against the Fearless Fund in 2024 on behalf of the American Alliance for Equal Rights.
The Fearless Fund was challenged in court last year by the American Alliance for Equal Rights.
The lawsuit alleges the company's grant program, quote, excludes applicants from the program based on race, and that the fund is expressly excluding all non-Black entrants from the program.
Well, it's very simple. Any policy or program that is racially preferential or exclusionary is against the law, and they have been for a long time. And the Supreme Court for the last 50 years has been very clear that the law prohibits racial discrimination in contracting, regardless of which race is being favored or being harmed.
The Fearless Fund specifically chooses recipients based on their race and sex, but even other organizations with broader DEI policies have come under scrutiny. In Students for Fair Admissions v. Harvard, Consovoy McCarthy represented Asian American students who alleged that Harvard University discriminated against them in its admissions process.
Harvard systematically raises the bar for Asian Americans and systematically lowers it for whites, African Americans, and Hispanics.
Like most Americans, we believe that America should be colorblind, race blind, and not race conscious. And so we have a strong interest in representing these various organizations that pursue this kind of litigation.
But how do modern DEI practices align with a colorblind vision of American equality? Are they an essential tool for achieving it, or have they evolved into a barrier to equality that should be re-examined? DEI initiatives have their roots in the civil rights movement of the 20th century, particularly in the wake of the 1964 Civil Rights Act. The Civil Rights Act prohibits discrimination based on race, religion, sex, or national origin, and specifically required the desegregation of public housing, public schools, and colleges. It also outlawed discriminatory voting practices, discrimination in federally funded programs, and created the U.S. Commission on Civil Rights and the Equal Employment Opportunity Commission.
What I try to emphasize to people is that the racial conflict and racial inequality in American society should not be seen as peripheral issues. They should really be seen as central to the project of American democracy.
We have only all been equal under the law since 1964. That is less than a generation. That's 1.5 generations, I guess, at this point. But what that means is we're not all starting from the same starting point. What we'd like to see is equal opportunity from the beginning of people's lives. And I think there's a lot of common ground between the left and the right about the desire to have equality of opportunity and a true meritocracy.
The civil rights movement created opportunities for outsiders to enter mainstream American institutions. African Americans and other racial minorities were admitted into American universities in ways they hadn't been before. Women began to enter the workforce. The immigration reform law in 1965 allowed immigrants from countries all over the globe. All this was unprecedented. And it also created challenges for institutions of all types. Universities, as well as employers, now had to figure out how to grapple with the new mix of peoples that they found in their workplaces and on their campuses. Affirmative action was a way to confront the fact that if you merely stop discriminating, that wouldn't do very much to help integrate America's elite universities nor America's workplaces.
Affirmative action is a term that originates from Executive Order 10925, issued by John F. Kennedy in 1961. This executive order required federal contractors to take proactive measures to ensure equality of employment opportunity without regard to race, religion, or national origin. The policy was expanded under President Lyndon Johnson, though recently revoked by President Trump amid growing tensions about DEI practices. However, the policy's decades-long history means that organizations across the country have established affirmative action programs, many of which have expanded in scope to resemble modern DEI.
When we look back to the 70s, most of the programs were diversity programs. Diversity was a thing that people were concerned about. Then over time, the E was added. People began to be concerned about equity. And equity is different from equality. When people think of equality, they think of sameness and treating everyone alike. But when people think of equity, they think of treating people fairly, which may mean treating some people differently from other people. Over time, the I was added for inclusion. On the one hand, we have an ideal with the Civil Rights Act of treating people without regard to irrelevant characteristics like race or sex or national origin. But on the other hand, after decades, generations even, of racial discrimination and subjugation, it would be unrealistic or maybe naive to think that simply not doing the bad stuff anymore would be sufficient to bring about the sort of equality that most people envision.
Critics of DEI practices say that they have expanded so far beyond the original scope of the 1960s civil rights legislation that they risk undermining the very principles the law was designed to uphold.
DEI is incongruent with civil rights laws. Oftentimes what DEI is trying to do is balance racial representation or get at certain outcomes by engineering those on the front end. What civil rights laws are supposed to do is guarantee equality of opportunity.
In recent years, there has been a certain segment of society that believes it is politically popular to engage in race-conscious practices, racially discriminatory practices. If they're deployed in a manner that actually engages in racial discrimination, either through policies of racial preferences or policies of exclusion, then that is a serious problem, legally, politically, and morally. Because the law forbids racial discrimination in contracting and forbids racial preferences in contracting or racial exclusionary policies in contracting.
When I was growing up, things were very black and white, quite literally. The only white person in our neighborhood was my mother. And things were sort of seen on that basis during that period of time. But today, the country is increasingly multiracial and multi-ethnic. I myself am married to a Vietnamese woman whose mother is a Vietnamese refugee to this country. And so our children are white, black, and Vietnamese. This is becoming increasingly what our country looks like. And so the retro nature of our discussions and about what we're trying to do for underprivileged people really needs to evolve.
There are socioeconomic disparities in this country, and sometimes those break on lines of racial demographics. But that does not justify using racial preferences to remedy those disparities. There is a way to remedy those disparities, however, and that is to look to help out those who are marginalized and disadvantaged in a socioeconomic manner.
When Students for Fair Admissions sued Harvard University, their case ended up in front of the Supreme Court in 2023. The Supreme Court ruled in favor of Students for Fair Admissions, saying Harvard's race-based admissions policy was unconstitutional. This decision overturned decades of legal precedent that had allowed universities to give preferential treatment to racial and other minorities, and it's what has paved the way for groups like the American Alliance for Equal Rights to move forward on challenging DEI practices in other contexts, like the Fearless Fund.
When Students for Fair Admission sued Harvard, and when that case got to the Supreme Court, it was apparent that this was a really big deal, and that this was not just about Harvard, but that this was about the use of race in undergraduate admissions more broadly. The Fearless Fund is related conceptually to the Harvard case, of course, because it involves racially preferential or exclusionary policy. Fearless runs what they call a Strivers Grant Contest, and that contest offers $20,000 grants to certain small businesses. Those small businesses are only ones that are owned by black women. So what Fearless is doing is engaging in contracting on the basis of race, excluding all other races. And so what they're doing, because it's racially exclusionary, is flatly against the law. In particular, Section 91 has been on the books since 1866, and the Supreme Court for the last 50 years has been very clear that it applies race neutrally. This is not to say that people who would like to support businesses owned by black females cannot do so. If the Fearless Fund was giving no strings attached donations to black female-owned businesses, Section 1981 doesn't have any interest in that. It's only the contracting that matters.
The American Alliance for Equal Rights sued the Fearless Fund, alleging that it violated Section 91 of the Civil Rights Act of 1866. The Fearless Fund presented various legal counterarguments, including that its programs were a valid form of affirmative action under the Civil Rights Act of 1964. The Fearless Fund initially prevailed on these grounds in the Georgia District Court, but when the case reached the Circuit Court, the ruling was overturned, and before it could reach the Supreme Court, the Fearless Fund chose to settle.
Had the Fearless Fund sort of kept fighting, I think the outcome would have been that that case would have gone to the Supreme Court, and that could have been very problematic for those who believe, like me, in inclusive capitalism, inclusive economics, and inclusive America, and certainly the value and impact of diversity, equity, and inclusion. But just the sheer fact that the lawsuits exist has instilled fear and intimidation in people and in organizations. So I have already seen where a number of venture capitalists, philanthropists, corporations, business leaders have pulled back on their funding and their support of initiatives, programs, offices, things that are really tied to driving more inclusive organizations and more inclusive leadership. So I think even without an outcome that's favorable or unfavorable, people have been scared and sort of intimidated into making changes.
What it says to me that the plaintiffs in both of these cases prevailed is that the overt use of race is just simply out of fashion legally. However, I don't think it's a total end to DEI, and I don't think it should be a total end when it comes to seeking true diversity, equality of opportunity, and true inclusiveness. Workplaces and colleges can still attempt to do that, and frankly, they should.
I think the lawsuits that we've seen in recent years really serve as fear-mongering because in the United States, often when we talk about DEI, we talk about it through the lens of race, but I think that we could easily be talking about it through the lens of class as they do in other parts of the world. And there are definitely white Americans who have been historically impoverished who I think would benefit from DEI policies. The most underrepresented constituency in Congress, for example, are blue-collar workers. So it's a really kind of curious thing that the people who are sort of seeking to abolish DEI and who are outraged about it often don't seem to think through who benefits from getting rid of DEI initiatives and who actually could possibly stand to gain from them.
If we could just remove the words DEI and just really think about the type of democracy that we want to live in, my question for those that are against it, because clearly I'm for it, is do you believe that we should have an inclusive America? Do we believe that there truly should be equal access and opportunity for all? And if there's not, that we should do something about it. Because the premise of this country is that if you work hard, you pull yourself up by your bootstraps, you can create a better life for yourself, your family, and broader communities. And I've been able to do that as a Black woman. So why wouldn't that same opportunity be afforded to others like me who've been underrepresented, overlooked, marginalized in this country?
Experts, along with the American public, remain deeply divided on how to best achieve diversity and equality in workplaces, universities, and other institutions.
A 2024 Gallup poll showed that about 70% of Americans agreed with the decision of the Supreme Court in the Harvard case. Most Supreme Court cases that are considered controversial are split right down the middle, but this one is far from that. A July 2024 poll conducted by the Manhattan Institute revealed that more than 2/3 of Americans, 68% they found, prefer race-neutral, colorblind policies over race-conscious policies. In an America where it seems like Americans have a hard time agreeing upon anything, it's particularly noteworthy that by 2-to-1 or larger margins, Americans are opposed to race-conscious policies.
We do need to bring forth more diversity of thought. We do need to bring forth more opportunity and create, quite frankly, new companies and new ideas. And so I don't think that that can be done without an acknowledgement of the inequities that exist. Representation, for me, above all else, matters the most. The more that there are people like me that are different, that are bringing unique perspectives, that have unique backgrounds, unique lived experiences, and are occupying spaces that are majority white, the better off I think companies, I think educational institutions, and I think America will be.
Civil rights laws are anti-discrimination laws for everyone. And there are certain protected characteristics that fall under those laws. We should adhere to them closely. If we don't, we're watering them down. I think we should also be educating employees, professors, students at colleges and universities, how they're protected by civil rights laws and what their obligations are when it comes to those as well. There's no reason why colleges and universities, employers cannot, and they certainly should, and they did before the DEI enterprise, cultivate a culture within their communities of respect, of tolerance and openness to others, and professionalism and civility within their workplaces. And those things combined with baseline civil rights protections and understanding of your rights and responsibilities is what an ideal way forward looks like to me.
For a lot of folks, because we live in such segregated ways, your workplace is the first place where you're really having the opportunity to interact with people different from you. And if we lose that, we just find ourselves more and more in our information bubbles and our misbeliefs about one another. And so that is making Americans not trust one another, not trust their institutions, and it's making it really hard for us to come together to solve problems.
People decide whether they're against DEI or whether they're for DEI, and then they huddle with their own like-minded peers. They disavow and vilify the people on the other side. And this is a poisonous dynamic. It's a dynamic that not only divides us from each other, it also practically precludes the development of the sorts of programs that we do need, because those sorts of programs are only going to come about if we can get the input and the best ideas from all segments of society. The path forward is going to involve working together and people learning from, even or especially those with whom they disagree. That's the hope I have.